Ready? Sean, you ready? Thank you. Well, I've got 5:30 on the dot, and so as planning director, without having a chair or a vice chair yet, I will call the meeting to order. And just want to make a note that it's great to see everybody again. I don't think the board has met formally in more than a year now, so
Yeah.
it's good to get you guys back together and good to see you again. Our first item of business are oaths of office. All of our regular members were sworn in at the beginning of their terms more than a year ago, but we do have two new alternates who were appointed fairly recently. And so we have Assistant County Attorney Michelle Horn here to administer oaths.
That would be Matthews and.
Rena Matthews and
Renee.
Renee.
It's okay.
William Pope, Bill Pope.
I don't think you got me. Hello. And, you can have you, swear or affirm, do you have a preference? Okay. You repeat after me. I, and state your name,
I, William Pope,
do solemnly swear
Do solemnly swear
that I will support and maintain the Constitution and laws of the United States
that I will support and maintain the Constitution and the laws of the United States
and the Constitution and laws of North Carolina, not inconsistent therewith,
and the Constitution and the laws of North Carolina, not inconsistent therewith,
and that I will faithfully discharge the duties of my office
and that I will faithfully discharge the duties of my office
as a member of the Board of Adjustment.
as a member of the Board of Adjustment.
So help me God. And each of you to sign.
Remember that.
I thought all day.
Sorry.
Yes.
It is, because I was like waiting on you to show me, I'm like,
Yeah, no.
Together.
yeah, like, see, good.
Are you gonna go over into this old business instead of gonna go straight?
Here's your hand.
Thanks, guys.
Minutes. Okay.
All right. Next item of business is the election of chair and vice chair. Article 3 of your rules of procedure require that you elect a chair and vice chair at your first organizational meeting of the year, which is according to the rules in January, but we haven't met since then or before. So I'll preside over the election of chair. Once we have a chair, I will turn the rest of the meeting over to the chair to conduct the election of vice chair and the remainder of the agenda.
Go ahead.
Yes, sir. I was just going to ask if there's a motion at this time for chair of the Board of Adjustment.
I'd like to make a motion for Ike Holt.
We have a motion for Mr. Holt to serve as chair. Do we have any other nominations for chair of Board of Adjustment?
I second that nomination.
We've got a motion and a second. All those in favor of Ike Holt to serve as chair of the Board of Adjustment, please say aye. Any opposed? Congratulations, Mr. Chairman. The rest of the meeting is yours.
Well, I appreciate the show of confidence again, and I'll do the best I can. Let's have the election of the vice chair now. I'll open the floor for nominations.
I want to make a motion that Mr. Cobb serve as vice chair.
Any other? Pardon?
I was asking, could I do him too? Or is it just one?
Just one.
This one.
Yeah, I would.
Is there any other nominees? Is there a second on Mr. Owens' motion? That's a motion for Ray Cobb to serve as vice chair. I'll second the motion. All in favor, say aye. All opposed? Congratulations, Ray.
Thank you, sir.
You may very well have to fill these shoes someday.
That'll be a tough one.
Might be sooner than you think. I trust everyone has had the opportunity to read 22 pages of minutes of our meeting of March 21st of 2024. If everyone has had an opportunity to review them, does anyone have any comments or see any changes that needs to be made to those minutes? If not, I'll be glad to entertain a motion that we accept the minutes of the March 21st, 2024 meeting of the Alamance County Board of Adjustment.
So moved. Second.
There is a motion and a second on the floor that we approve the minutes as recorded of the March 21st, 2024 meeting of the Alamance County Board of Adjustment. Any discussions? All in favor, say aye.
Aye.
All opposed? Thank you. The next thing, I'm gonna do a little swapping around on our agenda for tonight is making an amendment to the rules of procedure for our board. This may go into a little bit more discussion than what Matthew is aware of. I have a couple of ideas that I want to add. So rather than keeping the main focus of our meeting tonight postponed, and we have people here with us, we'll move on to the RV parks of the Triad variance hearing. So let me formally open that hearing now. As customary, I need to swear in all the people that will participate tonight. That includes county staff as well as members. And if there's anyone in the audience that would like to address this board later on, I will address that issue a little later. So if everyone that needs to take this oath will please stand, I'll be glad to administer it. I can get to the right page here. Okay, raise your right hand, please. I, and state your name, please.
I'm Matthew Vogler.
Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah, I do. Yes.
Thank you. Is there anyone in the audience that would like to bring anything before this board during the course of this variance request hearing? Okay, if not, we'll proceed. Matthew, will you please present to the board the county's position on this variance request and a little bit of history
Yes, sir.
of what's taking place?
Sir, thank you, Mr. Chairman. Applicant Myra Pravat, representing the development known as RV Parks of the Triad LLC, is requesting a variance from the provisions of section 6.14.1, subsection B1, road standards of the Unified Development Ordinance, which states, quote, RV parks shall have a clearway of 30 feet. Mr. Pravat has applied to construct a recreational vehicle park on the property located at 4441 Swepsonville, Saxville Hall Road. This development has already been reviewed by the county's technical review committee and is otherwise approvable pending other permit. On April 24th, 2025, it was discovered that a portion of the clearway is narrowed by the presence of an existing barn to the west side and three large oak trees on the east side of the travel area. This narrows the clearway down to 25 feet in this section and is depicted more clearly on the exhibit for variance, which was included in your agenda packet. Mr. Pravat is requesting permission to develop a 25-foot wide clearway in this particular section instead of the 30-foot wide clearway, as would otherwise be required. The UDO defines a clearway as follows, quote, a cleared area of land in a manufactured home park that is free of all obstacles that would prevent access by vehicles for emergency or other purposes. The clearway is privately owned by the manufactured home park operator, end quote. The standards for granting a variance are found in section 2.3.1A of the UDO, and they read as follows. When unnecessary hardships would result from carrying out the strict letter of the regulations, the Board of Adjustment shall vary any of the provisions of this ordinance upon a showing of all of the following. Number one, unnecessary hardship would result from the strict application of the regulation. It is not necessary to demonstrate that in the absence of the variance, no reasonable use can be made of the property. Number two, the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or to the general public, may not be the basis for granting a variance. A variance may be granted when necessary and appropriate to make a reasonable accommodation under the Federal Fair Housing Act for a person with a disability. Number three, the hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance is not a self-created hardship. And number four, the requested variance is consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved. As you deliberate tonight, please evaluate this variance request on each of the above criteria and make a determination on each for the public record. Pursuant to section 2.3.3 and state law, a 4/5 vote is necessary to grant a variance. And at this time, Mr. Chairman, I would like to enter all of the documents related to the variance into the public record, unless there is an objection, and that would include the email exchange with the fire marshals that came after the agenda packets were sent out.
Before I make a move on that, I'd like to poll each member now that we know who the person is asking for the variance. It's been recorded. I'd like to poll each member and see if there's any potential conflict of interest. Mr. Cobb, I'll start with you.
I'd like to recuse myself, sir.
Okay, you feel that you have a conflict of interest in this case?
I've known Mr. Papette for quite some time. I know Mr. Lawson, known him for quite some time, know Mr. Lawson's wife, know Mr. Papette's wife. I prefer personally not to be involved in this issue.
Okay, I'll accept that and allow you to be recused.
Thank you, sir.
Mr. Wilson?
I have no problem.
Okay, Mrs. Hyder?
No, sir.
Mr. Owens?
No, nobody involved here.
Okay, pursuant to the rules of procedure of the Board of Adjustment, we have two alternate members who was in attendance here tonight. And Mrs. Matthews, I believe that's you. So if you will come forward, please. Good way to get broken in.
It is. Everybody was sitting up here. I was like, okay, we're ready to go. I'm ready to listen. And wow.
For the record, please state your name.
Renee Matthews.
Okay. This is Renee's first meeting with the Board of Adjustment. So I want to take a little time to welcome you to the board and to let you know that you're here just for the variance request. Once we finish with this, then Mr. Cobb, if he's still available, will come back and take his normal seat.
Okay.
Also, let me say that this being, and I normally go into a presentation before I start, but because Mr. Papette is represented by Mr. Brown, who I know has versed him well in what a Board of Adjustment proceeding is, I'm sure, I didn't. So what we do here is, for your benefit, we're highly regulated by North Carolina general statute. We're a little bit different than most boards that are appointed by the Alamance County Commissioners, and that being a quasi judicial board, which most people don't even know what that is, we're almost like an appellate court. people come in with a variance request, we have to, as you saw earlier, swear the people in. And what we do has to be based on facts. Unfortunately, we can't just go by the way our heart feels sometimes. We have to be guided by what the facts is presented before us states. I trust that you was paying attention to Mr. Hoagland when he made his presentation.
I did.
Okay, fine. Is there any particular question that you would like to ask before we go any further?
No, you caught me off guard. I don't have anything right now.
Okay, okay. Well, let me tell you a little bit more. Once Mr. Brown and Mr. Prevet present their request for the variance, I'll open up an opportunity for us to ask questions. And the way I normally do that, I start out with one question and then I go to each member and ask one question. After that's over, I'll open it up for anybody to ask the question. Could be a question you had based on Mr. Wilson's what he said. So that's a little bit the way we'll proceed. Then there's also the 4 issues that Matthew touched base on, is things that we will vote on individually. And let me stress that if it's anything that you don't understand about this proceeding or we're doing, don't mind interrupting, and I will answer it to the best of my ability. And if my answer is not good enough, we'll go to some of these experts.
Okay.
And I welcome to you and Mr. Poe both to the board as alternates. Having said that, we had a little housekeeping we had to do there. Mr. Brown, would you like to present Mr. Prevet's position?
Yes, sir. Do I sit or would you prefer I stand?
You can sit right there. I'll be fine as far as I'm concerned.
Okay, well, it was interesting, when Byron that called me and said, I've got a hearing before the Board of Adjustment, and I thought to myself, well, I've been doing this 50 years this September, and I didn't know that the Alamance County had a Board of Adjustment. So
We're brand new, less than 2 years old.
it used to be, and Byron, he's gonna testify that he's been working on this for several years for this RV park. The critical issue for us is it a safety issue? And I think the file reflects that the fire department says that there's no passage issue over that short period of time or period of distance and the width. So that's the critical thing, but we've got to establish all of the facts that you need in order to rule in Mr. Prevet and RV Park's favor. I preface our presentation by saying that I thank you for your service. I did this for 15 years at the city of Burlington. And of course, you probably know I'm the city of Mebane attorney in-house, as well as at the Vernon Law Firm. So I've been doing this, like I said, 50 years. I have with me Chandler Woods, who is new with our firm, and he Southern Alamance high school graduate, and he is on the Board of Adjustment in the city of Burlington. And I asked Chandler all the way down, I said, how many cases have you heard? And he said 0. So we're all in the learning mode, if you will. I would like to hand up some exhibits that I think are important. One of the things that I like to do when I go to court or if I'm going to a board meeting is to prepare an order. Now, Mr. Hoagland and Ms. Horn will prepare the order, hopefully that you will rule in our favor, and if you don't, then they'll prepare the order anyway. But I prepared an order along that has a number of facts that we think are very, very important. And I've got some exhibits as well for that we're going to be testifying about. And typically in court, I wouldn't be testifying and affirming that everything I say is best. I would just put Mr. Provett on the stand and let him testify about everything, but, this quasi judicial is a little different, so I like to be sworn whenever I'm representing a party, to this. So with no further ado, I would like to, introduce Mr. Provett and, ask him some questions relative to this. Byron, state your name for the record, please.
Myron Homer Pravat.
And what is your relationship with the applicant RV Parks, the Triad?
I'm the owner.
And are
Only
you,
my wife.
are you the member manager as well?
Yes.
And, I will hand you a paper writing and, folks, y'all got a copy of this so that you don't have to look. And I'll ask if you can identify this site plan.
Yep. That's the site plan for 11 RV sites. At 4435 Swetsonville, Sackville Road.
And, how long have you been working on this project?
4 years.
And, prior to you, being here tonight, was there an RV park, ordinance, at all?
No, there wasn't.
And,
Only a mobile home park ordinance.
and, so that was a stumbling block for your proceeding with your RV park.
Right.
And how was that a stumbling block?
Well, the way they wrote the ordinance was there's a lot of things in the ordinance as it's written that really doesn't make a lot of sense for RV parks. And I would have to go into detail on that, but I mean, setbacks are an obstacle. At first we had a 60-foot clearway, not a 30-foot. But when you take in consideration all the land it takes to put in septic fields, then you got 40-foot setbacks. I even got a 40-foot setback from my property line, and I own the lot right next door to it. If you take a 150-foot wide lot and you put the setbacks in, then you gotta have a 30-foot clearway. It throws up obstacles. You got land you can't use for what I want to do with it. But I've managed, after Matthew came with the county, I went and spoke with him again, because I didn't think I was gonna be able to do an RV park. And after talking with him, we spoke of all this, and he said, you tell me everything you can do and what you can't do based on the ordinance. And I think I've met everything that was required for the ordinance, except for this one thing. And I realized that late in the process that barn and oak trees are there, and the roots from the oak trees are growing under the barn. And when Duke Power came in and put the electricity main lines in, there was a root coming off the side of one of those trees that's this big, headed right up under the barn. So it would be detrimental to try to remove those trees to put in for a 5-foot variance that I'm asking. So we want the ordinance requires a 30-foot clearway with a 24-foot wide road. I'm asking for this section in front of the barn to be 25-foot clearway with a 24-foot road. So the trucks, fire trucks or whatever will still have 24 foot of road to travel on in a case of any kind of emergency.
And let me direct your attention to this exhibit, and each of you have this exhibit as well. This is,
Back to that now.
does this exhibit, accurately, show the variance that you are requesting?
It does, yeah.
And does it show the 42-inch and 40-inch oak trees, of over 100 years in age as well?
Yep,
And does it show the barn that is also, at least 70 years old based on what we could find?
yes, it does.
And, I will hand you another exhibit, and y'all all should have the photograph of this. Does this fairly and accurately represent the position of the barn and the freezing issue?
It does, yeah.
And in addition to that, there is additional, photograph that I've given each of you. Does this fairly and accurately represent the,
It does.
and, I have two other, photographs, that are part of your package. Do these fairly and accurately represent the, status of the trees and barn on the ground?
Yes,
And, based on your, just the new understanding that there is adequate width during, over this short space, within which emergency and fire vehicles can access all of the property shown on your site plan.
Yes. And actually, there were 3 fire people came out to look at it when I was there one day,
Yes, sir.
because they want a clear picture of what was there. They all said there's no problem with it from their standpoint.
I'm gonna testify on this, these last 3 exhibits, which are GIS. Basically, we went back and took the aerial photographs as far back as we could off the county records. And they show that the barn existed, prior to 1984. So, the barn has been there for a long time. Mr. Rivette, I assume you did not plant the faith trees the other day. And I assume that you did not, build or enlarge the barn that's there into the,
The only thing we've done is cosmetic stuff to the barn.
okay? I would, Mr. Chair, I would tender all of those exhibits into evidence as part of this file. And I would point out that as Mr. Hoagland happened stated, that the fire department is satisfied with this particular 5-foot variance. I'll also note that on our one exhibit that has the highlighting spots in yellow, that the total square footage, it's a 6.69% total variance in the total roadway, but it's a very short distance, as shown on the this particular exhibit that you also have. So based on that, I think that we have satisfied the evidence for the unnecessary hardship. It is, in my opinion, as a professional land planning attorney, a public benefit and interest of having historic barns. It is also a public benefit in having trees that are 100 years old, the size that are there. You've heard Mr. Rivette testify that he has worked on this for 4 years with the county, and we appreciate Mr. Hoagland's cooperation and consistent assistance with the particular. And we think that this is consistent with the spirit, purpose, intent of the regulations, and that no public safety or other harm that may be created by this, and substantial justice is achieved. Hardship resulted from those items being there, the barn and the trees, when he purchased the property, and the use he wants to make of the property. He was unaware of that, of this particular regulation at the time. But I think public safety is being accomplished, and the hardship is shown by the particular location of the barn and the trees that need to be preserved. And we're happy to answer any questions that you might have about any of the exhibits or any of the statements that I've made.
Before we conclude this part of the process, let me rule on this packet that you have given us
Sure.
as to whether or not to admit it. Because we've not seen it until tonight, I have a couple of questions.
Sure.
Without having time to study and read through it. The pictures, who took the pictures? You did. So you're willing to swear that that is in fact pictures of the property? Okay. I'll gladly allow the pictures to be included as evidence. I'm a little bit reluctant on the rest of the packet that you gave us because we've not had an opportunity to look at it. Now, if you think it is critical that we take the time to read this, I'll certainly do that here now.
I don't think, Mr. Chair, that it's necessary to read this proposed order at all, and I will withdraw my request that it be entered into the record.
Fine,
It would be
fine.
Presumptuous on my
Fine.
part, really, but
Fine.
that is part of the process we go through whenever we're presenting.
Okay, well, let me rule that we will accept the photographs into the record. And, the other, since you'll withdraw that, we'll let that be where it stands.
And we would certainly want the exhibits on the
Yes,
actual site
Yes.
plan.
that was actually in our packet of, information from the county. So we were already aware of that. And I trust we've all studied that. Okay. Anything further that you guys would like to say?
Yeah, I have nothing further if anyone.
Okay, then I'll open it up for our questioning session.
Yeah, we would just reserve the right to address any,
Yeah, sure.
posing.
Certainly.
Factor is.
Certainly. Matthew, I have a question.
Yes, sir.
This 30-foot, clearway, I believe is, talks about, and that's in the unified ordinance, I believe. Is that, a state regulated? Where did that 30-foot come from?
I'm not aware of any state regulations with regards to a clearway or a right of way within RV parks. As far as I understand, that is completely local regulation specific.
Within the county.
Yes, sir.
It's just a county regulation for the 30-foot.
Yes, sir.
Okay, Mike, you have any questions?
Yeah, I got a few.
Okay.
You said one thing kind of concerned me. You said the roots are underneath the proposed driveway.
Mm-hmm.
Do you think that's gonna be a problem in the future? You already, I mean, you said you're worried about the roots underneath the barn.
Right.
So if they're going underneath the driveway, if they're gonna be a problem under the barn, I'm wondering if they're gonna be a problem in the driveway.
I couldn't tell you. I'm not an arborist, but
Do you know how wide a fire truck is? You know how wide an ambulance is? Who'd you have come out from the fire department, or was it fire department or the county, fire marshal?
it was that fire marshal,
Who was,
is it John Payne or Page?
John Payne.
but he didn't send the letter, the deputy, was it Jesse?
Jesse Gwynn.
You couldn't get him to send a letter, did you not ask him?
He told me he would get in touch with Matthew and let Matthew know that everything was okay.
Well,
And we've got an email that I think came from his office anyway.
that, one tree is closest to the barn, you know how many feet it is from the barn? Is that the closest one?
Yes,
Because sometimes pictures,
It's 25 feet.
and, you didn't consider taking that one tree out? It looks like if you just
Well,
took
the
that
rest-
one tree out, the rest of them.
No, they're all pretty close. They're all within that 30 feet.
I guess, Mr. Owens, we have the, June 16th, 3:32 PM from Jesse Quinn, Deputy Fire Marshal, Alamance County Fire Marshal's Office is satisfied with the proposed road width at the RV park at the Triad site. And I think Mr. Hogan referenced that already.
Yeah, I read it.
We have the benefit of those email exchanges.
For your information, I've done some research, I come up there. The fire truck is 10 foot average width. And so is the ambulance, average.
Good.
Depending on the fire truck, depending on the body maker of the ambulance, the 550 Ford is 106.5 inches wide, mirror to mirror. So if two emergency vehicles had to pass through there, it could be done.
It's one way.
Well, if they had to pass, I'm just saying, we've got, part of the variance appeals, public safety's gotta be considered. And, if you had an emergency in there, say it's one way, you got a lot of volunteer firemen that's gonna come out there, it's gonna be dark, I don't see any lights on your barn, it's a lot of things to consider. But, it just looked to me like, by this picture, like I said, if you just took that one tree out, it'd make it so much wider. It might make it, but, 2 or 3 foot, it looks like they make it. By this picture, like I said, pictures can make pretty on me. uh, the, he's talking about, they changed the game on it. These are two separate lots, correct?
The one now?
The two separate lots, two different deeds for these lots.
Yep, three,
Three.
Yeah.
So,
from what I own.
so the first part that you did, you didn't have all the rules that you got now.
Right.
But this vacant land that you had, that's deeded separate. That's when you went to apply for a new permit.
Mhm.
You'd have been grandfathered in
I was grandfathered in.
if it all been one parcel.
Mm.
If you was grandfathered in, we wouldn't be up here. I'd still be in the hayfield.
Well, it was grandfathered in from the first TRC meeting I went to.
Yeah, well, if,
That's what I was talking about.
if you got three or even two different parcels, the way I understand it, if I stand corrected, you correct me, Matthew. If you done this deal over here, but you start a new project on this other deeded lot,
I didn't do one though. It was what I bought was there. What I've got right now was already there, other than the infrastructure I put in for this RV.
what do you mean already there? What do you mean?
Well, I've got on one parcel of land, I've got 4 mobile home lots. That was already there. And then I was going to add, at one time I was going to add 18, and with the ordinance written where it was, I couldn't. So, but there's some mixed use.
But let's get back to the property then.
Okay.
The property that we're talking about right now,
Okay,
it didn't have any RV parks on it,
no,
no mobile homes on it.
no,
So it is a new product.
yep.
That's all.
Deborah, Sider, have any questions?
No, sir. I'm listening to all of it.
Mike Wilson, I'm gonna have to start dividing you guys up.
I reckon. No, I don't see any, issue. I wonder,
This is
looking at,
just for questions. Now, we'll
Yeah.
discuss it
okay,
next go.
yeah, I don't have any questions.
Renee,
Just
put you on the spot here.
It is, but it's okay. I do have some other questions, but I think that's for a later time. Just the questions of, any questions for just this? I don't, because Mr. Owens asked some very good questions, which helped me understand a little bit more. So I will pass for any additional questions on this part.
Okay. Matthew, is there anything further that the county would like to say?
There were a couple of points in there during the discussion that I thought about interjecting, but I didn't think it would be proper to interject. So you may have to refresh my memory on a couple of those items that were spoken about. To your line of questioning, this is, as far as the county is concerned, this is a new development. I believe there's old documentation from 2001 from the initial submittal. I'm sorry, 2021. Sorry. But typically with regards to TRC submissions, if a project comes through and then a year or more lapses, then it's basically a clean slate and a new proposal has to be entertained. And then regarding the email from the fire marshal, what I'm about to say may not ultimately, if you find it's not appropriate for the record, that's perfectly fine. I think that one thing to note that's important about the fire marshal's email is that, to me, there is a distinction between the road width, which is part of the fire code that they enforce, versus the clearway width, which is more of a unique feature of the county's ordinance.
And I believe Jesse addressed that in his email.
Yeah. And regarding that as well, so Mr. Payne is out of town this week. And he felt that if either him or Mr. Gwynn were going to weigh in on this, it would be better for Mr. Gwynn to weigh in on this with Mr. Payne being out of town this week. So that's why you got the email from the deputy fire marshal as opposed to the fire marshal.
Do you know whether or not Jesse went out and actually saw it himself?
I believe they have visited the site. Yes, sir.
Mhm.
John Payne, Jesse Wynn, and one other individual from the fire marshal's office.
Mhm.
We came out.
Mhm. One of the things, Mr. Babette, that we have to think about in our judgment is, we, since this is not on a property line issue, you do have other property there. And I'm sure the design of the lot itself is what caused the road to be put where it is. I understand that. But one of the things we have to be a little bit aware about also is setting precedents for other people in the county. You know, having been a member of the Alamance County Planning Board for a number of years, several years ago, we talked about travel ways and right of ways a lot doing those things. And in fairness to you, the fire marshal's office and rural fire departments had a big say so in those things about having adequate travel ways. It is a big issue. It is a big issue. Having myself owned a lot of big, heavy equipment, I know space and turning is critical also. But the point I wanted to make is that we have to also take into consideration, and I understand you're just asking for a small portion of the entire road for variance for just a small portion. But I think what Mr. Owens says is right. We don't want to see a bottleneck. You know,
This 24-foot wide road is wider than a state road.
yeah.
And so I don't,
I understand. I can't really myself get, in looking at these pictures, how quick does the road, how quick is it going to turn? And once you get to this building, I've looked at the proposed.
It did go straight by. I rode out there yesterday.
back in the back,
Uh-huh,
posted in the very back there on the other side of the truck.
uh-huh,
The road is on just this side of that.
okay,
So as far as distance, I'm gonna say it's probably 100 feet,
uh-huh,
be
okay,
my guesstimation.
okay. All right,
You'll see on the drawing where the road, we come in off Sweat Sacks Road,
yes,
then it turns to the right,
yes,
and it goes back toward the back there.
yes,
When it gets to the back of that main road there, when it gets back here is where it turns and goes by the barn.
uh-huh. Now, you lost me there. Show me that again, please.
There's a mention,
Right there, yeah, there's your barn.
Yeah,
it comes in here, of course, this is 30 feet wide, and then
Yeah.
you've got
and there's no question about any
34,
of that.
34, yeah.
That-
So 30, 65,
So
100,
here's the setback right here.
that's right, just that.
And where's the barn there?
The barn is right here, on the
Okay.
back side.
Right there.
Yes, sir.
Gotcha.
Yeah.
I'm sorry. I just had a corn.
That's fine.
I just had a cornea replacement 3 weeks ago yesterday. So my vision is not up to par.
Do we have a pointer that we can do it on the screen, what he just showed?
There's one on the podium.
Yeah, just what he just showed.
It's right here. What that little offset is in the barn, just sits right on the other side of the road from those 3 trees.
So with a lot to.
Yeah, so there's the 3
Matthew,
trees right there.
just for my information,
Yeah, just that one.
I know it really does not,
Oh, okay.
Um,
So here's the cutaway here for the barn. Come off Sweat Sacks Road, come down to here. And you're actually about 90 feet from the barn, these measurements. That 100, I guesstimation is pretty close. You come in and turn here and then it's 30 feet here. And during this section here, it goes down to 25, then opens back up on the other side of the trees and barns.
Ah,
I'm still not following you there.
that makes sense.
It's also depicted here more closely.
Okay, I see. That's the barn on the left there.
That's correct.
That touch, got you.
Barn here.
Got you.
It's 30 feet here,
Got you. Yeah, I understand.
25 in here, and then it goes back to 30 on the other side of the barn.
Okay. Thank you.
Matthew, to,
Yes, sir.
just for a question for myself, not pertaining to this variance. Is there, the ordinance allows for 90-degree cuts in a road with no clear sight?
Yeah, the road regulations in the RV park ordinance don't really speak to, right angles or the shape or the curvature of the road.
That's very unusual in road design. Usually, there'll be sight distances.
Yeah. This may be a little bit beyond this hearing, but I think that when the RV.
Yeah, I'm just personal information here.
Yeah, I would, so just generally, it would be useful, I think, for both administration and for developers if there were more clarification on those
Yeah.
types of elements.
Mr. Prevet, getting back to the new proposed road, is it going to hook on to another existing road? It appears it's going to hook on to another road.
Right here,
Yes, sir.
this, you pull that other picture.
Yeah.
Okay.
So that's a second access
Then this drive and then comes back out.
that's also to the Saxby Hall.
That's back out to
Stretchville.
Bill Saxon Hall Road,
Gotcha.
right here.
Uh-huh.
It's actually.
So that's why you said it was a one-way deal.
Right.
Can I ask you another question?
Sure.
Can we back up a minute? Mr. Bell? You made a comment that, you get started at and then the timeframe got you and you went back, start this. And you made a comment that he basically said, and I'm not putting words in your mouth, you tell me again, that he wants you to come back to him and tell him what you could do.
Well, what we're gonna do at the time was ask for variances if I needed them. But when I went and spoke to Mr. Hovland in the beginning, he said, went to the TRC meeting and I think he said we grandfathered in for that meeting. So he said to go back and just look and see what variances you need and what you don't need. So after
And
looking at it a little
who
further,
was that talking?
that was me talking to Matt.
Matt, okay.
So when I went back and looked at it, I figured a way that I had to rearrange some things, but I figured a way that I could meet all the ordinances until I ran into this issue here. I've met every other ordinance that's in the,
So,
written in
And we'll
old.
set back on the adjoining property which you own, cause you hardship too.
Yeah.
And I'm just asking, because it's at the back now, but was it even a possibility that you could have put both of those together, those lots together, then you could have done
Then
away
there a
with
mixed
setback?
use. Is that the reason we couldn't do that?
To put both of those lots
There's a
together,
residence, there's a house there.
I don't recall, I don't remember the details of the conversation, but I know that because there were already existing structures on that property, that we talked about how it would be easier to develop an RV park basically from a blank slate.
But I will say that I did get the measurements of the fire truck for the very reason you point out. I ain't had it in my notes, and I was gonna say it, but you never said it. For the freeway to be wider than the state highway, especially like the road I live on. They pass on it every day, and 10 foot wide. That's all I got.
Mr. Chairman, I feel like I should maybe clarify a little bit, if I may, just recalling our several conversations over the past many months or year plus. As I recall it, and this isn't speaking negatively at all, as I recall it, the first or second time I met Mr. Pravat, I was relatively new in the position. And from your previous interactions with the county, between then and our meeting, the county had adopted the RV park ordinance. From what I recall from our conversation, you were under the assumption that the RV park ordinance was particularly onerous and would make it difficult for you to develop your property. And the tone of our conversation was that if you wanted to draw up plans and submit them to us for our review, we could do, I'd be happy to go back and forth with you and talk about options and talk about configurations so that you could make use of your property within the spirit of the ordinance.
Right.
I don't recall suggesting that you request a variance. I don't know that I would.
You might not have requested that,
Okay.
but that's how I took it, that if there were any variances needed, then at that point, I could probably go. And back then, we used to go before, the planning department first, they would make their recommendation, then it goes before the county commissioners.
So that's the more of the tone of the conversations that I remember that we had.
Okay. Before I close the meeting to any participation from them guys for us to deliberate, anyone have any more questions? Any further questions? Anything more from you guys?
Just in summary, I think it's, safe. Excellent. Thank you to Mr. Owens for checking the width of, the service vehicles that we be concerned about.
That's what he paid you to do.
Anything further from you, Matthew?
No, sir.
Okay, then I'm gonna close the comment section and we'll deliberate this among ourselves now. I will say this, Mr. Brevet, and I'm sure Mr. Brown has already told you, the 4 questions that we have to take into consideration and act upon is required by state law. There again, it's sort of like when someone comes before us, it has to be factual. That's the reason, I question about the pictures, photographs, who took that. We had to be satisfied that it's factual. So, with that, Mike, what's your feelings? Mike Owens, let me tell you, I got,
In short, I would vote to give him the variance.
you would vote
Yes, sir.
to give him a variance, you said? Deborah, how do you feel about it?
I agree with that.
Mike Wilson?
Same here. I rode out to the site yesterday and just rode through it. And I've driven big pieces of equipment. Used to drive a 45-foot bus and I could have put it through there 30 miles an hour if I needed to. So I don't have a problem with it.
Renee?
So I agree. It was just a short section that was down to 25. I mean, everything.
And it's great.
Exactly. And everything else was in order. So I agree.
Okay. One of the things that we can't consider here is the expense that's associated with any improvements. The ordinance, the state law says specifically that that's not an issue that we can take into consideration. One of the things that I think a little bit about was I know it's expensive to have trees taken down.
Yes, it is.
I had some trees taken down last year. 3 trees around the house cost me $10,000.
Takes a long time to grow a tree,
Yeah,
especially one that size.
it does. So, I know that, it's, something to think. Okay, having said all that, there's no further discussion.
No,
Okay,
just that I think he meant on 4.
well, let's go one by one just for the record. And I'd like to have a motion on each item individually. I'll read them out. Unnecessary hardship would result from the strict application of the regulation. It is not necessary to demonstrate that in the absence of the variance, no reasonable use can be made of the property. I'll be glad to entertain a motion based, yes, sir.
Yes, sir, Mr. Chairman. I'll just make a quick note that as you make your motions and seconds and put a point on it, whether you vote yes or no, a statement of finding of fact is helpful in building a proper case.
Yes, that's the reason
Summarize
in the
case.
motion, we'll need some statement of fact.
Yes, sir.
And also, for our new member, I didn't tell you this, for this variance to be approved, it takes a 4/5 vote. It's not just a simple majority vote. Under our normal regulations, it's a normal, just a regular majority. But under a variance request, it takes 4/5. So does anyone have a motion for me on item number 1?
I'll make a motion.
And what does your motion say?
He does meet that unnecessary hardship, for several reasons, but one, right out of the gate, because of that ordinance, the 30 foot, when the state road's only 24 foot. So he's been put in a hardship and on his particular land, the state is playing by a different set of rules.
So let me make sure, and let me restate it to make that I understand. You're making a motion that we say he does have
Yes,
an initial based on
the
He's-
fact
the
that,
fact that the state of North
Yeah.
Carolina
yeah,
on their DOT roads does not require a wider travel way. That's a motion. Is there a second?
Second.
Any discussion? All in favor, say aye.
Aye.
Let it be shown it's unanimous. As to requirement number 2, I'll read it. The hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. A variance may be granted when necessary and appropriate to make a reasonable accommodation under the federal fair housing, talking about handicaps, which doesn't apply. I'll be glad to entertain a motion here as well.
I'll make a motion that it satisfies the paragraph 2 of the, whatever you call it,
Okay, based on what?
based on that, it's particular to that condition. You got trees and a building, which would be a hardship to replace or to move.
Okay. Let me make sure I understand.
All right.
You're making a motion that we say that the hardship results from conditions that are already there,
Yes.
okay? And that you don't think it needs to be moved. And it really does not create a hardship that's not workable.
Correct. I mean, Mother Nature could move it tonight. Who knows? But we don't need to be requiring him to move it.
Okay. So there's a motion and a second on the floor. As to the second question, that the hardship, creates a handicap that is really not a hardship in this situation to not grant a variance. Is that fair?
I think, I'm not sure exactly what you said. You talk like a lawyer. You're talking in backwards.
Yeah. In other words, what we're saying here is what your motion is, that in the second, that we don't consider it a hardship that it can't be overcome.
Correct.
Is that good enough for you, Matthew, for the?
Yes.
Okay.
Yeah.
We'll have that in a second.
All in favor, say aye.
Aye.
All opposed, let it be shown.
Did you get a
as
second for that motion?
I don't
I've got
believe
it.
so.
I've got a first, all right.
Yeah,
first.
We didn't have a second.
I'm sorry.
I'll say.
I'm sliding in my old days. There's a first and a second. All in favor, say aye.
Aye.
All opposed, let the record show as unanimous. The third hurdle, the hardship did not result from actions taken by the applicant or the property owner. The act of purchase of property with the knowledge of circumstances that exist may justify the granting of a variance if it is not self-created hardship. I'll be glad to entertain a motion here.
That's pretty much already been stated, hasn't it?
I'd say.
Yeah.
So you make a motion
Oh, well,
that the hardship is not a result.
so if anything he did.
Right.
I second.
Okay. There's a motion and a second. Any discussion? All in favor, say aye.
Aye.
All opposed? Let the record show that it was a unanimous decision. The last hurdle, the requested variance is consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved.
I'll make a motion. It's obvious that Alamance can go through there, pass through there easily. Fire truck can pass through easily. So safety is not gonna be concerned.
Okay, any second?
I'll second.
Okay, let me restate the
Got
motion.
your name on the minutes, bitch.
Let me restate the motion that,
Renee.
is required with item 4. There's a motion to say that the variance is consistent with the spirit. And that emergency, it is the view of the board that it is adequate for emergency vehicles. Any discussion? All in favor, say aye.
Aye.
All opposed? Let the record show, please, that it's unanimous again. Mr. Prevett, I believe you'll be able to proceed. The county will forward to you shortly a letter that, and I think that's what Mr. Brown was talking about earlier. I'll have to sign some documentation, but that'll be out to you shortly.
Okay.
Matthew, can you give him a time on that, maybe roughly?
Well, let me just read for you the statute, so everybody's on the same page for exactly what the procedure will be. So this is 160D-406J decisions. The board shall determine contested facts and make its decision within a reasonable time. When hearing an appeal, a quasi judicial decision is effective upon filing of the written decision with the clerk to the board, that's me, or such other official as the development regulation specified. The decision of the board shall be delivered within a reasonable time by personal delivery, electronic mail, or first-class mail to the applicant landowner and any person who has submitted requesting a copy. The person required to provide notice shall certify to the local government that proper notice has been made, and the certification shall be deemed conclusive in the absence of fraud. So I think ideally the board will approve of it at the next meeting, get the signed documentation, and then mail it to the applicant.
At the next meeting, or next March.
No, we're going to address that
Oh.
with some further business here tonight. That's the reason I put something off here earlier.
Third Thursday in July.
Yeah, we're going to address that here shortly. Okay, then let me
Thank you all very much.
close this variance request.
Thank you.
Thank you.
Yes. Renee, thank you for your service tonight.
You're welcome. Thank you for
I-
breaking me right on in.
I would ask that you, if you'd like to stay
Okay.
to hear these discussions, because it will concern you a little bit,
Yes, sir.
be the right way to, I think that under the rules of regulating our board, I think that we need to have a meeting in January, like our rules call for. And also, after a variance request, I like to see it in our rules that we are required to meet within, and this date is flexible with me, either the next stated meeting date or within 60 days. The reason being, I'm a little bit variable there, is because of Matthew and his staff. They, you know, there's 22 pages of minutes with our last meeting. I'm not sure that tonight will be quite that extensive, but that's a lot of work for those guys. Now, I want to ask Matthew his input, because I'm hitting him blindsided with this. I hadn't said anything to him about it. Matthew, do you think 30 days is a reasonable time for you guys to be able to come up with the minutes? Where I'm coming from is, in the event that, like, the prior variance request we have that we denied, should they have wanted to take that to Superior Court, I think it would be a black eye for the county if we had not officially signed off the minutes of that meeting. And I also bear some responsibility, have been chairman of the 2024 board, that I didn't insist that we had a meeting earlier. So I want to get that. I think it would be good to put that in the rules of how we operate this board. And so I want to discuss that among ourselves and see how you guys feel about it. I just think that we need to stay ahead of the ball, you know, and that if you know, if it's always as smooth as this, it's no big deal. But, you know, if it comes down to a contentious deal and we turn somebody down, and it may be a big dollar investment involved with the people that's asking for a variance, then it's not really good on our part to say, well, it's going to take us 3 months to get these minutes approved. Because as far as the board is concerned, our work is over here tonight, with the exception of approving or not approving the minutes. So, Mike Owens, what's your thinking about it?
I don't have a problem, 60 days after.
Let me get back to Matthew. What about the 30 to 60?
I think 30 is fine, and I think, so you and I talked about this a few days ago, but we switched to the Microsoft Teams platform, which does a really good job of transcribing minutes. So after the fact, we've got to go back in and make sure everything is accurate, but we've got a really good template to start from. And that's
so you don't anticipate having to do all this by hand in the future.
So that certainly takes some time. I also just think that just kind of philosophically or procedurally, that the county owes it to folks that come before the board and take the time to request a variance. They owe the decision in a timely manner so that they can proceed. They can lawfully proceed with their development within the confines of what they did.
It could be a big monetary deal involved.
Certainly could be. Yes.
So you're saying 30 days is adequate?
I think 30 days is fine. There's also, and I may have just read this a few minutes ago, but part of that same clause says every quasi judicial decision shall be reduced to writing, reflecting the board's determination of contested facts and approved by the board and then signed by the chair. So after the last meeting,
I don't think they were approved. I just signed.
Well, I guess there's kind of a question. Is it approved by the fact that you guys just discussed, did your findings of fact, and then voted on each individual one? Is that the approval they're referring to? Or is the state law referring to approving it once it's been condensed and reduced to writing? Maybe there's a little bit of a question there, but the best thing that we could do is just get it approved.
If we adopt these new rules, excuse me, if we adopt this new rules package, then that'll be a moot point.
Exactly.
It'll be within 30 days.
Yeah.
Or 60, whatever we decide.
Or just say the next regular meeting.
Yeah.
Because the
Next stated
the
regular.
meeting should be the third Thursday of every month.
Right. And that's something we got to take action on here tonight also.
Well, I mean, if you're gonna be that considerate and thinking about the people that's, you got put on hold, why can't we do it like we're doing it tonight? And go ahead and prove it.
Well, we got to see it's recorded though.
Do it now.
We need to see the recorded copy.
Well, what he just said, we just approved it literally. So, I mean, is this just a procedural thing or just the chairman needs to see it?
Mm-hmm.
If that's
Well,
the case,
Read that again.
That the decision shall be reduced to writing. So I think the assumption is that we, after the meeting tonight, we go back, we summarize, we package up formal minutes as is normal, and then that will be approved after the fact.
Okay. Deborah? What's your thing?
Think so.
Since we get
Yeah.
paid so much to come up here, you know, we get. Okay,
That
so,
was a lot to go through that, but it was very interesting.
so you would support
I would,
those changes to the
Yeah.
rules?
yes.
Mike Wilson?
I'm not sure exactly what you're saying. You're
We're
saying
not talking
30 days.
about this yet. We're not talking about this yet.
Well, I'm,
What
why
I'm,
can't we tie these together? That's
Because-
what I'm thinking about right now.
because this is gonna change every year. Right now, what we're talking
Well,
about
if you
is
get your
changing the
meeting
rules.
dates and they're every 30 days, when we make a decision, we can say, okay, we're gonna skip a meeting and go to the next one, but have these dates to where we can plan our own personal stuff
Yeah,
and not
yeah, we're gonna,
have it dropped on us, you
yeah,
know,
yeah, yeah,
30
yeah.
days ahead.
We need, this had to be done every year, and it needs to be done in January.
Sure.
It needs to be approved at our first meeting in January. And then we'll approve the minutes at the next stated meeting after an action has been
Mhm.
taken.
Right.
A hypothetical situation is, after we meet in January and elect officers,
Mhm.
then we may not need to have another meeting until July. But
Right.
if we have a variance request in July,
Right.
then we would meet in August on the next published.
Right. Right. That's what I was.
Yeah, but I don't think
Thinking-
we need to tie it together because we
Well,
got
I'm
to vote
saying
on
use
this
these
tonight.
dates as
We'll do this yearly.
yeah.
Yeah.
And then we say, okay, at our next regular scheduled meeting is
Right,
when we'll
Right.
approve them or do
Exactly.
whatever we got to do as a board.
And that's a 30-day deal.
Hmm.
How about you, Ray?
I like it.
Okay.
I think it's a good idea.
All right. Any other discussion about it? I mean, it's, I just feel like we need to do something. It needs to be addressed and get it in the rules of operation in that way. Okay, that being said, I'll be glad to entertain a motion.
So, Mr. Chairman, if I may just make a recommendation. So one thing we could do, your motion could be to instruct staff to revise the rules of procedure. And we can add it specifically in there in the rules of procedure that whenever the board hears a variance and makes a determination, that the decision shall be rendered and finalized or reduced to writing and then approved at the very next meeting.
Yeah,
So we can present that amendment to the rules of procedure in the July meeting.
that sounds good to me. Ray,
I like it.
so does that mean a motion?
We'll call it this. That's what we'll take.
So let me make sure. Is there a second?
A second.
Okay, there's a motion and a second that we change the rules of procedure for the Alamance County Board of Adjustment to say that we will meet in January of each year. We will meet at the next stated meeting after an action is taken pertaining to a variance request.
We're going to have a meeting when action is requested.
Yeah, but
Then,
that's a given.
Yeah. And then after the determination, we have to have a,
That's right. At the
The
next
next meeting.
meeting. Any other discussion? All in favor, say aye. All opposed? Let it be, let the record show that it was unanimous. Now, in our packet, we also had the dates for our meetings for this year. I'll be glad to entertain a motion that we accept those dates.
so moved.
Sorry.
There's a motion and a second. It is in this one. I'll take a minute and look at them. It's on over toward the back. I think it's before though, maybe I'm sure. Maybe it'll move back. No, that's the memo.
Oh, yeah.
Yeah. You got them. It's in
It's
some of
in
that.
here. I see it. That's it. Like,
They're up on the screen.
they're in here. I just gotta,
Okay,
they'll be in here.
okay.
Yes.
So is there a motion that we accept these dates for 2025?
I thought it had already been,
I thought it was too.
Oh, okay. I'm slow.
motion and seconded.
I'm so, okay,
So
yeah,
we
we're
read-
discussing. That's right. Any further discussion? All in favor, say aye.
Aye.
All opposed, let the record show is unanimous. Okay, I believe,
When you, in your discussion of amending the rules of procedure, did you specifically include in the motion the relocation of the
no, we did not. We need to do
meeting
that.
location?
Yeah, we need a motion that we adopt the change of meeting location.
Yeah, and I'll just briefly summarize what you're looking at here. So the highlighted text is both old and new. The struck through would be old and the underline is new. This is just simply stating that your new meeting location is this room specifically. And that just comes because the old room where we were meeting has now been converted into the jury room. And so it's off limits for these types of board meetings. Yep. So this is just really minor housekeeping.
So I'll be glad to entertain a motion.
Make a motion.
Second.
There's a motion and a second that we accept the commissioners' meeting room for future meetings. All in favor, say aye. Any discussion? All in favor, say aye.
Aye.
All opposed? Let the record reflect that it was unanimous that we use this room. Okay.
Till they tell us it ain't available.
Well, then they get us in a new law with. Okay,
In the new development services building.
that's right. Is there any further anything further to come before the board tonight? Ray, you have anything?
Good.
Mike Wilson,
I'm good.
Deborah,
Yes, sir.
Mike Owens?
They buy supper.
Right. Okay, I'll be glad to entertain a motion for adjournment.
Move.
Second.
There's a motion and a second that we adjourn the,
Say no more.
all in favor, say aye.
Aye.
See you on
Okay.
July 17th.
Okay. Thanks, everybody, for